determination of facts which patient or probable cause that will be further heard in the proper hearing by this committee. So it is only proper that the recital of facts should at this stage be at least supported by evidence for us to declare that the complaint is sufficient not only in form but also in substance. Thank you, Madam Chairman.
Thank you.
Madam Chair.
The Honorable De Lima, and then Honorable Co, and then Honorable Tino, and then Honorable Garbin. Okay, one after the other. And then Honorable Rodriguez. The Honorable De Lima is recognized.
Thank you, Madam Chair. Good morning, everyone. Technically and strictly, and if we go by the standard set the House rules itself, the rules of procedure in impeachment proceedings, it's supposed to be just, we just have to look at whether the complaint has a recital of facts constituting the impeachable offense charged and determinative of the jurisdiction of this committee. I don't think there's any issue on the jurisdiction. This committee has jurisdiction. Now, the recital of facts constitutive of impeachable offense charge, in addition to what has been articulated earlier by the Honorable Chairperson about, it must not be based on conclusions. I would wish to further elaborate on exactly what sufficiency in substance mean. When we talk about substance, it refers to whether the complaint alleges ultimate facts that, if hypothetically admitted, would constitute an impeachable offense. So hypothetical admission lang. Hindi pa natin titingnan kung totoo o hindi, o may supporting evidence ang isang allegation of fact. And as I said, in addition to the standards set in our own rules of impeachment, rules in impeachment proceedings, a complaint is sufficient in substance when it, number one, narrates specific acts or omissions, not mere conclusions. Number two, it shows a nexus, a connection between the acts complained of and an impeachable ground. Kailangan konektado yung mga allegations of facts doon sa constitutional ground. Number three, should be intelligible and coherent, allowing the respondent to meaningfully answer. Number four, it's not purely speculative or opinion-based. And then, pwede rin, in terms of just checking the sufficiency of the entire complaint, whether we can also look into whether it's supported by annexes or references, although proof need not yet be conclusive. Dahil nga po, evidence is not weighed at this stage. The test is allegational sufficiency, not credibility or truth. Yun po ang aking position. Thank you very much.
Thank you, Honorable De Lima. Now we recognize the Honorable Co.
Thank you, Madam Chair. Good morning to the committee. Once again, I also submit and I agree with the manifestation made by Representative De Lima. And I would just like to add further in regard to the discussion on ultimate facts. Given that actually the rules of court superiorly applies to the rules on impeachment under Section 19, I'd like to read Rule 8 of the Rules of Court of the Philippines, wherein it says that pleadings are required to set forth ultimate facts on which the party relies for a claim or defense. And as stated earlier, the ultimate facts are generally what is the allegation of the offense, the acts or omissions, and how it relates to the offense charge. That's different from evidentiary facts, which is not required to be included in a pleading yet, and that can come later on when we enter the hearing proper. And it's different also from conclusions of law. So right now, what is on the floor is the determination whether the ultimate facts are alleged in the pleading. No? And so, given that we're at this stage right now, we will determine whether the complaints are sufficient in substance as to whether ultimate facts alleging the offense charged is sufficient for this body. That's all. Thank you.
For the guidance of all the members, our parliamentary status, we are determining whether or not the question of personal knowledge and authentic records, specifically with respect to the attachments, should be considered in the determination of sufficiency in substance. Moving forward, we now recognize the Honorable Tino.
Thank you, Madam Chair. The Honorable De Lima and Co, they have eloquently made the point that at this stage, this committee is not supposed to determine facts. This is not the proper stage for that. That will involve the hearing proper. No? So at this point, the complaints may be determined as sufficient in substance if they are found to allege facts that constitute a ground for impeachment. Hanggang dun lang po. Hindi pa po natin papasukin kung totoo ba talaga o hindi yung mga allegations sa complaint. Yun lang po, Madam Chair. And as to the question of authentic records and so on, my position there is that dapat tinanong yun kahapon. Dahil yun yung precisely, yun yung inaalam, no? Whether or not the verification requirement was satisfied. At ang sinasabi dun sa verification that the complaint is based on personal knowledge and or authentic records. And that has already been settled by the committee. Thank you, Madam Chair.
Thank you, Honorable Tino. Now we recognize the Honorable Garbin.
Thank you, Madam Chair. We are all guided here by the rules of impeachment of this House, and the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. The complaint before us, filed against the President, alleging impeachable offenses, namely culpable violation of the Constitution. Major allegations by category is the surrender of former President Rodrigo Roa Duterte to the ICC. It is noteworthy to mention, Madam Chair, and to this honorable committee, that the case before the Supreme Court questioning the constitutionality of the said alleged surrender and kidnapping, case of GR number 278762 in the matter of the petition for the writ of habeas corpus of Rodrigo Roa Duterte is still pending. In fact, the status of the case right now is that parties were required to file position papers. And so, therefore, Madam Chair, to my mind, these are mere conclusions, not established facts, Madam Chair. And later, I will manifest my findings on the major allegations such as the culpable violation of the Constitution, and will declare my vote and explanation to my vote, Madam Chair. Thank you.
While the opinion of the Honorable Garbin on the first offense is significant, we will be holding our discussion on the first offense until we thresh out the question on whether or not we will consider the attachment if they are authentic record for the purpose of determining sufficiency in substance. That is our parliamentary state right now. The Honorable Rodriguez.
Madam Chair, after hearing the discussions, I am fully satisfied.
So before we proceed to our discussion on the offense, that is kidnapping, we wish to thank the significant views and opinions as to the question of whether or not the attachments should be considered for the purpose of determining sufficiency in substance, no? And I understand that there are varying opinions. Some members would say or said that they should not be considered and we should stick on what are stated in the impeachment complaints, while some would say that they are necessary for the purpose of determining the substance or the sufficiency in substance. The chair wishes to elicit a motion as to whether or not we will include the attachment if they are authentic records for the purpose of determining sufficiency in substance as a preliminary matter.
Madam Chair.
The Honorable Ko.
Okay. Madam Chair, I move that for this portion of the discussion, the body contemplates whether the facts alleged in the complaints constitute the offense charged. And at this stage, we do not need yet to cross-check or check it whether it is supported by the evidence, be it based on personal knowledge or authentic records. I so move, Madam Chair.
Madam Chair,
The Honorable Rodriguez.
point of order.
The Honorable Rodriguez is
The
recognized.
Honorable Ko is a party of the case as the endorser also in these particular proceedings. And so therefore, we will request all the endorsers that in the deliberation of the committee, they cannot participate. This is a proceeding akin to a preliminary investigation. And so the complainant and their lawyers could not be the one moving to the prosecution to proceed with the case. And so therefore, with due respect, let us allow our members, and of course, we will appreciate you at the proper time in the discussions to elaborate further the complaints. But as already parties, the party is the De Jesus complaint, Attorney De Jesus, and Jet Nisay, the endorser. Masa, the three respected gentlemen and lady. And so, the other party is the President Ferdinand Bongbong Marcos. And we are the committee investigating. So therefore, let us wait for another member to move whatever is the motion about. So I would like to seek the ruling of the chair.
Would you like to comment to that, Honorable Ko, before we rule?
Okay. Thank you, Madam Chair, Honorable Rodriguez. While I understand the logic of the manifestation, we'd just like to manifest that the three complainants of the second impeachment complaint are members of the Committee on Justice. So again, we also respectfully seek the ruling of the chair in regards to this matter, whether or not we can participate in the deliberations of the discussion on the first impeachment complaint, because as at least provided by the rules, it is a right that is provided upon the members of the Committee on Justice. Thank you, Madam Chair.
The chair recognizes the right of each member of this committee, notwithstanding his dual capacity of being an endorser as well. So, in resolution of the question as to the capacity of the Honorable Ko to raise a motion, the chair rules in favor of the authority and right of the member, notwithstanding the fact that she is an endorser as well, to raise the necessary motion.
But Madam Chair,
Before that, Madam Chair, we respect that ruling. Would therefore, in the voting of these two complaints, will Representative Ko be voting?
To the honorable members of this committee, we are exercising a very important process, and it is not the intention of this committee to impair whatever right and authority each of the member has in this committee. So if we are upholding the right of a member who is at the same time an endorser to raise a motion, we are likewise upholding her right to vote on the motion. Honorable Ko?
Madam Chair, before I answer, perhaps in the order also of the matters, given that we'd like to thank the Madam Chair on the ruling, but in deference on the discussions, I'd like to retract my motion and would allow the body to make that motion, given that there's this question. But nonetheless, we, as a member and in deference to the ruling of the chair, we will continue to participate in the discussions.
The chair has ruled already.
Okay.
The motion by the Honorable Ko is
Sustained.
upheld by the chair.
Okay.
So I will just be requesting for the rephrasing of the motion because it should not entail the evidence aspect of the attachment. The question only is whether or not the attachments as authentic records should be considered for the purpose of determination of sufficiency in substance. We are not yet on evidence. The Honorable De Lima is recognized.
Given the withdrawal by the Honorable Rene Co of her earlier motion, may I therefore make this motion? I move to exclude in the consideration of sufficiency in substance the determination of the authenticity of authentic records, if any, as attached to the complaint.
There
Do not
is,
consider.
there is a motion to exclude the authenticity of the attachments for the purpose of the determination of sufficiency in substance. Do I hear a second? Is there any objection?
I object, Madam Chair.
The motion has been objected to. We shall now divide the House. Those who are in favor of the motion, please raise your right hand. For the guidance of everyone, the motion is to exclude the authentic record constituting of the attachment for the purpose of the determination of sufficiency in substance. Those who are in favor of the exclusion of the attachment, please raise your right hand. You may put down your hands.
Madam Chair.
Let the chair restate the motion. The motion is to exclude the issue of authenticity of attachments for the purpose of determination of sufficiency in substance. In other words, whether we exclude or not. So if you vote in favor, we exclude the issue of authenticity of attachments. If you don't vote in favor, then we discuss on the issue of authenticity of attachments.
Chair,
The Honorable Tino.
may I clarify that the exclusion of the determination of authenticity is only for this stage, no? Because the position is
Of
that
course.
that should properly be done in the proceedings proper.
Correct.
Not at the stage of determination of sufficiency in substance.
Correct.
Para malinaw lang po, kasi baka isipin na yung motion ayaw na ma-determine kung authentic ba yung records o hindi. Ang sinasabi lang po, hindi po ito ang tamang panahon para
Correct.
gawin yun.
Okay.
May I be recognized, Madam Chair?
The Honorable SDML is recognized.
Just for purposes of determination of sufficiency of substance, I vote not to exclude. I vote to include.
That's
Kasi baka merong mga impeachment complaint na wala naman palang attachment o hawsyaw ang mga attachment. I am not saying na we will discuss the contents of the attachment. That would be for the proper hearing after we determine the substance. Ang sinasabi ko lang, dapat kapag may recital of facts, ang naka-attach dito ay mga dokumento na may probative value naman for proper hearing. Para hindi hawsyaw o haka-haka lang ang recital of facts. I submit, Madam Chair.
Madam Chair.
The Honorable Keith Flores.
Madam Chair, at this point, Madam Chair, I think it's enough that we rely on the verification under oath by the complainants themselves that it is based on true and correct facts and that it is also based on authentic records under oath, Madam Chair.
Madam Chair.
The Honorable Ridon.
To be very clear po, I'm only pertaining to the first impeachment complaint, and it's actually it's just a factual question. Which of the attachments are in fact certified through copies, no? Gusto lang ho namin malaman. We are not conflating this question on whether or not this proceeding should in fact even proceed. Kasi sa totoo lang, kahapon po, I was raising it already in the determination of form na in fact, in previous impeachment proceedings, an impeachment was denied, rejected by the committee on the basis of the absence of personal knowledge and authentic records on the question of sufficiency in form. So ibig ko sabihin, if we will not be allowed to determine this at this point, kailan pa ho natin yun madedetermine, hindi ba? So yun lang ho actually, and it's not even my question. My question is basically just factual. Doon po sa first impeachment complaint, alin po doon sa attachment, yung sa totoo lang, certified true copy, at alin po doon sa mga yon, yung hindi, without conflating it onto whether or not this complaint should proceed.
Madam Chair,
Honorable Rodriguez.
thank you. We are not yet there. We are still, the requirement really is just recital of facts, ultimate facts. In fact, the annexes are really would pertain to what is stated in the complaint. That is why it's annexed. We cannot go to the annex now because we are only, according to the rules, only focus on the recital of facts constituting the offense, and the complainant should be able to put in that complaint, in the recital of facts, what are the basis why the respondent will be liable under the 6 grounds provided by the Constitution. And that is why we don't yet go to the annexes. They are already mentioned in the complaint because otherwise the annex standing alone cannot stand. It is to enforce a statement of fact in the complaint. Thank you, Madam Chair.
Thank you, Honorable Rodriguez. For the guidance of all the members, we've heard a lot of varying opinions. Some are in favor of excluding the attachments for the purpose of determination of sufficiency in substance. Some are not in favor. But for the guidance of everyone, before we proceed to voting, we are requesting the Honorable De Lima to restate the motion.
Thank you, Madam Chair. I move to exclude the determination of the authenticity of the annexes, the records as attached to the complaint, at this stage of the proceedings, which is the determination of sufficiency in substance.
All right, the same has been seconded, and the same motion was objected to by the Honorable Ridon, and that is now, we are now dividing the House. Those who are in favor of the motion is to exclude. Raise your right hand. You may put down your hands. Those who are against the motion, please raise your right hand. You may put down your hands. Those who abstain, please raise your right hand.
Madam Chair, can I just say my,
Please wait, Vice Chair Dumogan, until we resolve the motion. Can we have the number of votes? Let me reconfirm. I find the numbers a bit doubtful. Okay. The motion, again, is to exclude the determination of authenticity of attachment for the purpose of determining sufficiency in substance. Those who are in favor of the motion, please raise your right hand. You may put down your hands. Those who are not in favor of the motion, please raise your right hand. With 21 in favor of the motion and 24 against the motion, the chair declares not to exclude the authenticity of the attachment in the determination of sufficiency in substance. So ruled.
Madam Chair? Madam
Thank you,
Chair?
Madam Chair.
Madam Chair?
Can I call first Vice Chair Dumogan?
Thank
Vice
you.
Chair Dumogan and then Honorable Tino. You're
That's very
recognized.
short. Thank you, Madam Chair. I'm happy that we voted against the motion because if we voted in favor of that motion, it will be violative of Section 3. The Section 3 requires based on authentic records. In all of a sudden, in the determination of sufficiency in substance, you will waive the determination of authenticity of document. It's violative of Section 3.
Thank you,
Madam
Vice Chair Dumogan. The Honorable Tino?
Madam Chair.
The Honorable Tino.
Thank you, Madam Chair. Madam Chair, in view of the fact that the chair herself had to call for a vote 3 times, and in the second instance, she even commented on the record na hindi siya makapaliwala sa resulta. Okay? So in other words, medyo wala pong clarity dun sa naging botohan. I move for nominal voting on the point, Madam Chair.
The Honorable Flores is recognized.
Madam Chair, Congressman Tino, I saw the numbers admitted by the Secretariat. We lost on both counts, sir.
Let us be reminded that this is just a preliminary matter, no? I hope we will be recognizing the decision of the majority of the committee in as far as this issue is concerned.
Madam Chair.
The Honorable Ko.
Thank you, Madam Chair. Madam Chair, with due respect to the members of the committee, it is this representation's belief that hindi po actually dapat subject to ng vote because the rule provided in the rules on impeachment proceedings that in this stage, to determine the sufficiency in substance, ang kailangan pong gawin is to determine whether there's a recital of facts constituting the offense charged. That's it.
With all due
hindi po
respect,
ito
the
nakalagay
Honorable Ko,
otherwise.
the committee has ruled already. The Honorable Garbin.
Thank you, Madam Chair. I've been hearing the position of the movant, and they invoke the rules of court as in suppletory character. Now, while impeachment is a political process, the determination in sufficiency in substance is analogous to a judicial requirement that a pleading must allege ultimate facts constituting a cause of action, not mere conclusions of law or argumentative narratives. Under Rule 8, Section 1 of the Rules of Court, pleading must state the material facts relied upon and not evidence on general averments of wrongdoing. Applying this standard, Madam Chair, by analogy, the first complaint largely asserts labels and conclusions, such as the betrayal of public trust. And therefore, it is but right that the majority of the members should assert to include and determine the authenticity of the attachment in the said complaint. Thank you, Madam Chair.
The Honorable De Lima.
Just a short comment, Madam Chair.
You're recognized.
Given the vote to still include the determination of the authenticity of supporting documents or authentic records, I believe it will unnecessarily delay the proceedings and prejudice the causes of any complainant. And it went outside the very essence of what is the determination or what is sufficiency in substance, as explicitly laid down in our own rules. Tatagal po ang proceedings at unfair sa mga complainants and labag dun sa ating rules natin. Recital of facts constituting the offense charged. So what is the point of looking into or inquiring into the authenticity of supporting documents? That's my view, Madam Chair.
Thank you.
very
The
much.
Honorable Flores.
Madam Chair, I agree with Congresswoman De Lima. And I have also seen the complaint and the attachments for the impeachment complaint against the Vice President. And it's voluminous, Madam Chair. And if we follow that rule on that impeachment complaint, it will take us forever.
Madam Chair.
The Honorable De Lima.
Thank you very much, Madam Chair. In view of these views expressed post-voting, may I move for reconsideration of the decision of the majority?
For the guidance of all the members, the question of the committee right now is only with respect to whether or not the records are authentic. It doesn't go into the truthfulness of the contents of the attachments yet. which is evidentiary already, no? The motion which we voted upon only pertains to whether or not we will include the issue of authenticity of the attachments. And I think that will be answered by merely checking on whether they are certified or otherwise. We are not looking into the truthfulness of the contents of the attachments yet, because we all agree that that will happen during the hearing proper of this proceeding. So with the indulgence of all the members, we have voted upon this motion. This is merely preliminary. We have 5 grounds to discuss, 5 offenses anchored on 3 grounds to discuss. We shall now proceed to hear the comments and manifestation on the first ground. That is kidnapping and surrender of the former president constituting either culpable violation of the Constitution or betrayal of public trust.
Madam Chair.
Is this about the first
No, it's
offense?
still about the annexes, Madam Chair.
We have ruled on that issue already. So,
Madam Chair, let's
in the
proceed.
interest of
Let's
time,
proceed.
in the interest of time and with the indulgence of all the members, let us proceed to hear the comments and manifestations on the offenses and whether the same constitute a ground for impeachment.
All right, I just wanted to state for the record, Madam Chair, that proceeding to the first ground,
The first offense.
the first offense, most of the annexes are news articles. I'm stating it for the record. There are only, for the entire complaint, there are only, I think, 3 annexes that are official records on which I'm asking on whether or not there exists a certified true copy for it when it was submitted to the House. No? So this is Annex U, transcript of Committee on Accountability of Public Officers and Investigations, Blue Ribbon, 25 September 2025. Annex L, Supreme Court decision dated 3 December 2025, Pimentel versus House of Representatives. And Annex A, Committee Report, Committee on Foreign Relations. Everything else, Madam Chair, are actually news articles that had been submitted as attachments to this particular complaint. And I think there is particular relevancy to it because I'm quite certain that it might be insufficient for evidence to be based on mere news articles only. So going to the allegation relating to kidnapping and arresting the president and bringing him to The Hague, I think it needs to be stated, Madam Chair, that the arrest of the former president is in pursuance of a treaty obligation between the Republic of the Philippines and Interpol. So, wala pong batayan para sabihin that the former president was kidnapped. More importantly, kidnapping is a legal conclusion and it does not constitute as a statement of fact. No? So, dun pa lang po, parang meron na pong problema yung pong ground po na ito. So, to be clear, ang annex po on the matter is Annex A, Committee Report, Committee on Foreign Relations. Annex B, Senate probe reveals lapses in Duterte's arrest. Daily Tribune, 27 March 2025. Annex C, Duterte ICC arrest. Inquirer, 27 March 2025. At Annex D, VP Sara on father's arrest. GMA News Online, 20 July 2025. But I think it has already been sufficiently established, Madam Chair, that this was not a kidnapping. This was an implementation of a warrant that had been issued by the Interpol, in which Interpol sought the assistance of the Republic of the Philippines to implement this particular arrest warrant against the former president. To be clear, this is not in pursuance of a relations between the International Criminal Court and the Philippines, because this relation has already been broken when we had left the ICC in the previous government. So, para malinaw lang po, walang batayan para sabihin na meron pong pananagutan ang ehekutibo dito po sa pag-aresto sa dating Pangulo at pagdadala po sa kanya sa International Criminal Court, Madam Chair.
Madam Chair.
The committee notes the manifestation of the Honorable Ridon. The Honorable Chu is recognized.
Thank you, Madam Chair. Madam Chair, I share the observation of the Honorable Terry Ridon, and I also submit that there is insufficiency in substance for a very simple reason that we all should be guided by the elements of the crime alleged, which is kidnapping. Ano po ba para pumasok sa kidnapping? Maliwanag naman po sa ating revised penal code. Number 1, kailangan yung offender is a private individual. Dito pa lang po, wala na po, tapos na po yung usapin. Pangalawa, dapat po ay yung act, dapat po the act is illegal or the deprivation of liberty is without legal justification. Maliwanag naman po that the arrest of the former president was via warrant issued by the International Criminal Court. So dito pa lamang po sa dalawang elementong ito ng kidnapping, wala na po, kulang na po. Kaya masasabi ko po na yung offense charge will not be sufficient in substance. Thank you po, Madam Chair.
Madam Chair, may I
Thank
be
you.
recognized? Madam Chair.
The Honorable Po, and then Honorable Chel Jokno, and then Honorable De Lima. And then Honorable Vice Chair Dumogan.
Madam Chair, thank you for recognizing me. Just for clarity, would it be possible to ask the endorsers if they're aware of any kidnapping cases that were filed against any members of the administration in relation to the ICC arrest?
May we request the endorser, the Honorable Nisay, to answer the question of the Honorable Po?
Madam Chair, sagutin ko lang yung kabuuan. Attached sa DSUS complaints ang ilang dokumento o public records at pati na rin sa mga news articles kasi sila ang pinaka-accessible.
If I may interrupt, Honorable Nisay, the question is very specific. Whether or not you are aware of a case of kidnapping filed against the impeachable official.
Am I aware, Madam Chair?
You are?
Aware of that.
So you are aware that there is a case of kidnapping filed against the impeachable official?
No. That there is no, ma'am.
Okay. So does that satisfy your question, Honorable Po?
Yes, Madam Chair. The reason why I asked that is because in order for us to determine that kidnapping had taken place to begin with, if there was kidnapping, shouldn't there have been a case filed against any administration official involved in the ICI arrest?
You mean not only the impeachable official?
Not only the impeachable official, because even if
Madam
we're saying
President,
responsibility-wise,
Madam Chair, the
shouldn't
President
the
is
case have
immune
been
from
filed?
suit, and therefore
That
there's
is
no
correct.
case pending before this President.
All right.
But Madam Chair, even if the President is immune from suit, no other official in the administration has a case pending regarding kidnapping.
Okay.
Am I
To
correct?
complete the question of the Honorable Po, he's asking if you're aware of any case filed against any government official in relation to the alleged kidnapping and arrest of the former president. Honorable Nisay?
Yes, Madam Chair, I am aware that no pending case.
He is aware that no cases were filed against any government official.
That's all, Madam Chair. Just wanted to establish that for the decision-making of those who will be determining substance on the grounds of kidnapping.
Thank you, Honorable Po. Honorable Jokno is recognized.
Thank you, Madam Chair. First, a point of clarification on the ruling of the chair and of the committee. Does this mean that during the next phase or the evidentiary phase of these proceedings, the complainants will not be able or will not be given the opportunity to authenticate their documents? Because I believe that that is a part of due process that should be accorded during the evidentiary phase. I am concerned because this ruling will have an effect on other impeachment complaints, that if we adhere to this and strictly apply it, that would we would be depriving complainants of their day in court. I'm very concerned about this, Madam Chair, because as I understand it, we go first through the form, which is a very simple process. We then look at the complaint in terms of sufficiency and substance, which, as Congresswoman De Lima said, is simply looking at the allegations of the complaint and hypothetically admitting that they are true. And then, only after that, do we look at the evidence and allow the parties to authenticate their documents. I don't think there's any requirement at all in our rules that require that all documents upon filing of the complaint already be duly authenticated.
The Honorable Vice Chair Dumogan.
Let us read Section 3 of our own rules. Second paragraph. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. There we are. The rules of the impeachment of the House requires that those documents to be attached must be based on authentic records. That's what I was pinpointing.
Madam Chair.
I might somewhat agree with you, but that is our own rules.
May I respond, Madam Chair? The way I understand it, that matter should have been taken up when we discussed the form in terms of whether the verification was proper or not. We have already gone past that stage. We are now looking at the sufficiency and substance of the complaint. And later, assuming it is sufficient in substance, I think we have to give the complainants the opportunity to substantiate, authenticate their submitted documents.
Madam Chair,
The Honorable Tino.
in addition to that, I would point out that the requirement in the determination of sufficiency in substance, where it says that the complaint must be a verified complaint, meaning to say it is based on personal knowledge and or authentic records, that requirement is satisfied through the submission of a verification duly sworn to and notarized. So for purposes of these preliminary stages of the impeachment proceeding, for as long as there is a verification duly notarized, then that requirement that this is a verified complaint has already been satisfied. Lagpas na po tayo doon.
With the
Madam Chair.
indulgence of the members of the committee, let us all be reminded that we've ruled already on the issue of the inclusion or exclusion of the issue of the authenticity of the attachments. As to the question of the Honorable Jokno, whether we will be allowing its authenticity during the reception of evidence, we reserve the discussion of that issue as we reach that matter, which is the reception of evidence during the hearing proper. We are reminding the members of the committee to confine the discussions and manifestations to the offense which is being discussed at the moment. We are on the first offense. The Honorable Padiernos.
Madam Chair, may I proceed to propound some clarifications and questions?
Is it on the first offense?
Yes, yes, Madam Chair.
You may proceed.
I would like to address the questions to the Honorable Nisay. So, for clarity, the grounds for the first allegation is based on culpable violation of the Constitution and betrayal of public trust. Is that correct, Madam Chair?
The Honorable Nisay.
Yes, Madam Chair.
Madam Chair, may we know from the endorser which specific, in terms of the culpable violation of the Constitution, which specific provision in the Constitution did in this case, the President violate?
Representative Nisay may answer. The question is the specific provision of the Constitution which was violated by the impeachable official.
Yes, Madam Chair.
Madam Chair, can request 2 minutes break.
Of course. Let us be reminded by our understanding about the sufficiency in substance that the offense alleged we should be able to connect the offense alleged to the ground of impeachment under which the same is anchored. And I wish to believe that this is the rationale behind the question of the Honorable Padiernos, why he is asking what specific provision of the Constitution was actually violated in relation to allegation of the kidnapping and arrest of the former president. Would you like to move to your next question or manifestation while the endorser thinks over the proper answer to your question?
Madam Chair, this is very important because according to the rules of the House on impeachment, in determining the sufficiency and substance, we must determine whether there's a recital of facts constituting the offense charge. So this is very important to know which exact provision of the Constitution did the impeachable official violate.
So, Madam Chair,
You're recognized, Honorable Nisay.
under po the due process, nirerespeto po natin yung Constitution.
It is the due process clause.
In that sense, Madam Chair, would well, may we know from the endorser that whether any Philippine court has issued a finding that there was a violation of due process or that the arrest constituted kidnapping?
Madam Chair, none so far.
So in this case, Madam Chair, it would appear that on the basis of the first ground, there is no impeachable offense. And to add on to that, Madam Chair, may we know from the endorser whether there is an actual written presidential order with regard to the arrest of the former president.
Madam Chair, wala po, pero under the directive po yung ng presidente, ang PNP.
Congressman Padiernos, he's saying that The PNP was under the directive of the impeachable official, that's why. Notwithstanding lack of order coming from the President.
But again, Madam Chair, we are determining here there must be an overt act personally attributable to the President or the impeachable official. So how can we say that the impeachable official should be liable because of the supposed action of the PNP in this case?
Honorable Nisay, Honorable Padiernos is asking for the overt act committed by the President or the actual participation with regards to the alleged arrest and kidnapping.
Madam Chair, I think yung dapat po na wala siyang ginawa. Yun po yung...
So, Madam Chair, is omission equivalent to an impeachable offense?
Madam Chair, for us po, is a yes.
I rest my case, Madam Chair. I would just like to manifest that based on the answers propounded by the endorser, and with due respect, this representation does not believe that on the first ground that there is an there is a recital of facts that would constitute the offense charge being culpable violation of the Constitution and betrayal of public trust. That's all, Madam
The
Chair.
committee notes the manifestation and answer of the endorser. The Honorable Suntay.
Thank you, Madam Chair. Through you, Madam Chair, on the first ground, alleged culpable violation of the Constitution, the complainant alleges that the President ordered or enabled the arrest of and surrender of the former President Rodrigo Duterte to the ICC, did so without a valid Philippine warrant, therefore violating national sovereignty, due process, and constitutional guarantees. Would that be correct?
Yes, Madam Chair.
So the legal theory asserted, Madam Chair, is that the ICC surrender constitute a constitutional violation and therefore an act of betrayal of public trust. Would that be correct?
Yes,
Honorable
Madam
Nisay.
Chair.
And may I know, Madam Chair, through you, may I know what would be the evidence to support these allegations? I was reading the complaint. I saw Senate committee reports, media articles, statement of public officials, and it was limited to that. Would there be any other?
Madam Chair, yung mga news articles, yung mga publicly available published articles. Kasi sila po yung pinaka-accessible na form ng public record na nag-reflect ng mga event timelines at statements na alam naman ng public. Gaya po ng sinabi ko kanina, isa sa mga layunin ng mga news articles na ito ay mag-establish ng pattern na mayroong nangyayaring graft and corruption, culpable violation of the Constitution, betrayal of public trust. Kumbaga sila ay mga circumstantial evidence na pag nag-combine ay magpo-form sa conclusion na karapat dapat nang i-impeach ang ating presidente dahil siya ay karapat dapat hindi mamuno.
So, Madam Chair, through you. So, based on your answers on the first grounds being alleged, the only evidence are news articles and clippings. Therefore, you are attributing these actions to the President. Are there any arrest orders signed by the President?
That question has been answered already, Honorable Suntay.
Executive issuances or documentary proof of direct command?
Madam Chair, wala po.
So, does that mean that we are alleging a constitutional offense committed by the President just because the former President was well, the ICC was allowed to well, not arrest, because to try the former president.
Yes po, Madam Chair.
So, Madam Chair, based on the answers of the endorser, on the first ground, on my position is that the allegations is not sufficient to form an impeachable offense on the first ground.
Okay. For the guidance of the members, we need not state our position with respect to the sufficiency. All the questions, manifestations, and comments will be taken in consideration as we vote on the entirety of the impeachment complaint with respect to the sufficiency in substance. Nonetheless, the position of the Honorable Santay is duly noted by the committee. The Honorable Po and then the Honorable De Lima. Is this still on the first offense?
First offense, but wrapping
You may
up.
proceed.
Madam Chair, on the first offense, just to give clarity to everything that we've spoken about at the moment,
Kindly speak louder, Honorable Po.
just to give clarity on what was taken up so far, the endorser is claiming that there is a betrayal of public trust based on kidnapping, which, as we've discussed here, no cases have been filed, on a violation of due process, again, in which no cases have been filed, because of command responsibility in which the PNP was acting under the President. Again, no cases were filed against any member of the PNP for either a lack of due process or for kidnapping. So just for the members of the committee who are deciding on this matter, on the substance of the first grounds, it would be important and prudent to note that there are no cases filed as attested to by the endorser. And if our determination of betrayal of public trust is based on kidnapping, which wasn't affirmed, and betrayal of due process, I feel that this may be something we should take a closer look at, and maybe we should wrap up already on this discussion and move on to the next grounds.
Madam Chair.
The Honorable De Lima.
Thank you, Madam Chair. So we're talking about the first ground. The general ground, the general ground is culpable, or the ultimate ground is culpable violation of the Constitution and betrayal of public trust. The supposed supporting factual allegation is ordering and enabling the kidnapping and surrender of the former president to the ICC. Now, for this specific factual allegation, I point out 3 sub-allegations. One is that the former president was arrested without Philippine warrant and forcibly transferred to ICC. I say that these are insufficient allegations of facts in terms of time and date, place of occurrence, persons involved, and events that transpired. Complainant, I humbly submit, cannot presume judicial notice of sequence of events that transpired in the former president's arrest. He must allege the specific facts of the arrest relevant to this ground of impeachment, and not merely a general allegation that the former president was arrested and transferred to ICC. The second sub-allegation is that allegedly PBBM resorted to foreign intervention and ignored domestic legal processes. I say that these are legal conclusions and not allegations of fact. Even if this is to be treated as factual allegations, complainant must state the specific acts laying down the conclusion that PBBM resorted to foreign intervention and disregarded domestic processes. The complaint must answer the question of what were the specific acts committed by PBBM that constituted consenting to foreign intervention and disregarding domestic legal processes. Again, the complaint cannot presume judicial notice of the events that transpired
on that day. The third, the last sub-allegation of fact. PBBM surrendered the former president, FPRRD, to a foreign tribunal. I say again that this is a legal conclusion and not an allegation of fact. Even if this is to be treated as a factual allegation, the complaint must still allege the specific acts, that constitute the surrender of FPRRD to a foreign tribunal. Complaint cannot rely on judicial notice to establish the specific acts that constitute surrender to a foreign tribunal, which is in fact also debatable, especially in light of alternative versions that FPRRD was not surrendered but arrested by virtue of an ICC warrant in accordance with RA 9851. So to me, Madam Chair, the first allegation is not a sufficient allegation of fact, but mere conclusions lacking in specificity. So insufficient po para sa akin yung first ground.
Madam
Thank
Chair.
you.
Thank you, Honorable De Lima. Now we recognize the Honorable Alvarez.
Given the lengthy discussions, listening to legal luminaries
On the first offense.
of the first event of the complaint, even given that the president was there during the planning of the execution to serve the warrant, even if he committed error in judgment, is not an impeachable offense. Therefore, given that the first complaint on the Jesus complaint has no substance, Madam Chair, I move to dismiss the first complaint.
We are not
the Jesus
finished with our discussion of the offenses and as to whether they constitute an impeachable ground.
Therefore, I modify my motion to consider the first allegation as insufficient in substance.
Madam Chair.
We cannot entertain that motion as well because we will be deciding on the entirety of the complaint after we have deliberated upon the 5 offenses alleged in the complaint. Nonetheless, the manifestation of the Honorable Alvarez is duly noted.
Madam Chair.
Any
Yes.
other
Madam
manifestation,
Chair.
Honorable Alvarez?
I maintain my motion subject to further deliberation of this committee, Madam Chair.
The motion is considered as the manifestation by the Honorable Alvarez.
Madam Chair.
The Honorable Rodriguez, then Garbin, then De Lima.
Thank you, Madam Chair. I'd like to ask propound questions to the endorser, the Honorable Jet Nisay. Are you aware that there is an international organization called the Interpol, International Police, Criminal Police Organization, which was created in 1956 by the United Nations, by the General Assembly in 1956, and the Philippines is an original founder and signatory of this convention.
Yes, Madam Chair.
And of course, you're aware that the ICC has issued a warrant and it requested the Interpol, the international organization, wherein we are members, to cause the arrest of the former president in the Philippines.
Yes, Madam Chair.
So the arrest is not based on the order of the president or anybody in this country, but it is pursuant to an implementation which we are duty-bound to therefore cause the arrest of the former president because the ICC has issued a warrant of arrest. Would you agree with that?
Do you? Madam Chair, dapat po yung position natin dumaan sa judicial system muna natin.
But Rule 59 of the Rome Statute of the International Court of Justice precisely provides for the arrest. Now, you are saying, that's a good point, because you said that it should also go to the court. That is also provided in the Rome Statute. And that's why there's also an issue on the rendition, because you stated here surrender. And of course, that's another issue. The first issue is the arrest. And clearly, the arrest is legal because it is upon our compliance of international law. Now, so the rendition, there are many views. And would you therefore agree that this particular issue is now pending in the Supreme Court, Congressman Nisay, because in the cases of, first, in the matter of, for the record, Madam Chair, in the matter of the petition for habeas corpus of Rodrigo Roa Duterte, petitioner Sebastian Z. Duterte, against the Honorable Lucas Bersamin, it is GR number, to put on record, the number, Madam Chair, is 278-73, and the other cases brought about by Veronica Duterte and also by Paulo Duterte, which in seriatim was also filed, then you agree that there is a pending case, and the main prayer of these particular cases, are the following. It is stated here in the prayer. It is questioning the arrest and the surrender of the President to the International Court of Justice. Are you aware of that, International Criminal Court?
Yes, Madam Chair.
So therefore, with your answers, the Honorable Jet Nisay, then there is no kidnapping, because kidnapping means that there is no power of any person to be able to get into detention a person. And therefore, in this case, there's a warrant of arrest, and it was executed by our country, which is a signatory to the Rome Statute. And as for the issue of rendition, surrender, it is already the Supreme Court, and according to our rules of judice, we cannot discuss here cases the Supreme Court. Whatever we say here. Once the Supreme Court comes out with a decision on these cases, on the validity of the arrest, of the bringing of the President, the rendition to the ICC, is a matter already in the Supreme Court. You agree with that, Mr. Jet Nisay? These are facts. You are stating here that there is kidnapping, there is illegal surrender, but the facts are that precisely Interpol, arrest. Rendition, the issue is in the Supreme Court. Would you agree with that?
Yes, Madam Chair.
Thank you.
Pero
Madam Chair.
ganun din pa.
I wish to remind the House members, the committee members, that if you can express your point by way of manifestation instead of question, we will encourage that. That is in the interest of time, because we have 4 other offenses to deliberate upon. Now we will move to the recognition of the Honorable Garbin.
Thank you, Madam Chair.
Let us all be reminded that this is just preliminary. The endorser will be very much ready to answer all the exhaustive questions when we reach that hearing proper of our proceedings. So kindly limit our question, and if you can translate it into manifestation, that would save a lot of time. Thank you.
Madam Chair, on the first allegation, culpable violation of the Constitution, the endorser alleged that, or avers that, he based his allegations grounded primarily on media reports and public documentary. Culpable violation of the Constitution, in the records of the deliberation of the Constitutional Commission, defined as willful and intentional violation of the Constitution. Commissioner Mambong, I'm referring to the records of the Constitutional Commission, stated that culpable violation of the Constitution means willful and intentional violation of the Constitution and not violation committed unintentionally or involuntarily or in good faith or through an honest mistake of judgment. How can we decide on sufficiency, on substance, grounded on mere allegations, primarily based on media reports and public documentary? In fact, I refer to the case referred and mentioned by Congressman Rufus Rodriguez in the case of petition for writ of habeas corpus of Rodrigo Roa Duterte. It's still pending before the Supreme Court. And the House, and that is precisely the reason why there is a pending case before the Supreme Court regarding the legality of the arrest. And to render it illegal at this point and attribute the same to the President is still premature and baseless, Madam Chair. The House will then be placed in a very awkward situation wherein a President is being tried for a supposed illegal arrest when the same is subsequently ruled as legal. So I therefore submit that manifestation, Madam Chair. Thank you.
Madam
Thank
Chair,
you.
point of order,
Thank
Madam
you.
Chair.
Before we proceed, we've heard a lot of opinions, comments, and even questions from the members with respect to the first offense. So it is the intention of the chair to limit the succeeding members who will be asking on this offense so that we can move to the next offense. Nonetheless, we recognize the Honorable SDML Lawrence Defensor.
Madam Chair, just a point of order on the way we proceed with the deliberations. Let's just address our manifestations as the complaint alleges. We don't have to interrogate the endorser. The Honorable Nisay is not the complainant. Let's just make manifestations and simply state the complaint alleges the following and state our manifestation. Thank you, Madam Chair.
We encourage the committee members to follow the suggestion of the Honorable SDML Lawrence Defensor. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Pursuant to the instruction of the Chair, and has already been suggested, let me manifest that on ground one, there's no impeachable offense. We all know that there's no kidnapping. Second, the arrest was by virtue of an arrest warrant issued by the International Criminal Court because of an offense which had been allegedly committed when the Philippines was still a member of the ICC. And it was coursed through the Interpol. So, and let me point out, with all due respect, looking at all the complaints, there's actually no narration of facts. It just stated and went to the arguments. So, I am forced to, of course, manifest that the respondent did not commit any betrayal of trust or culpable violation of the Constitution with respect to allegation number one. I so submit.
Thank you, Vice Chair Dumogan. With that, the Chair wishes to move to the second offense. Please allow the Chair to read. Respondent is a drug addict whose condition impairs his judgment and leadership. This is anchored on the ground of culpable violation of the Constitution and betrayal of public trust. At this juncture, we elicit the manifestations, preferably manifestations, of the committee members with respect to its sufficiency in substance.
Madam Chair,
The Honorable Agbas is recognized.
with respect to allegation number 2, although the complaint claims the respondent is unfit to serve as president due to drug addiction, it fails to allege the ultimate facts showing how this alleged personal condition translated into any impeachable act. It does not narrate when the alleged use occurred, how it was committed, or how it affected any official function. It simply concludes that the respondent is unfit to serve without providing the facts required to demonstrate an impeachable offense. Further, no factual narration of an official decision, directive, or exercise of presidential power impaired by, connected to, or caused by the alleged addiction. That's all, Madam Chair.
Any other member who wishes to make a manifestation on this?
Madam Chair,
Madam
may I be
Chair.
recognized?
The Honorable Barbers, and then De Lima, and then Suntay. One after the other. You are recognized, Honorable Barbers.
Thank you, Madam Chair. A manifestation. One of the grounds stated in the impeachment complaint filed by Attorney De Jesus and endorsed by Representative Nisay is the allegation that the respondent is a drug addict whose condition impairs his judgment and leadership. The complainant asserted that the respondent is unfit to serve as president due to drug addiction. He further alleged in his complaint that the respondent's refusal to submit to drug test conclusively demonstrates his disregard for transparency and accountability, and concluded that the respondent's silence and evasion confirmed the public suspicion and betrayed the trust of the nation he swore to serve. Madam Chair, let me point out that this assertion in the complaint was based solely on the alleged statements of the sister of the respondent, Senator Amy Marcos. The complainant attached copies of news articles containing reports on such statements of Senator Amy Marcos and forms part of the complaint. Under the rules of procedure and in impeachment proceedings, the requirement of sufficiency in substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. There is no evidence or authenticated records submitted by the complainant that will support his allegation that the respondent is actually using illegal drugs. The complainant did not even mention that he has personal knowledge of the drug addiction of the respondent. Such allegation of illegal drug use by respondent, which was reportedly stated by another person and not the one who filed the complaint, is mere hearsay and lack probative value. On the other assertions by complainant that the respondent is unfit to serve as president due to drug addiction and that his refusal to submit to drug test are all speculative and without any factual basis. I humbly submit, Madam Chair, that the ground for impeachment of the respondent on his alleged drug addiction that impairs his judgment and leadership is insufficient in substance. Thank you, Madam Chair.
The manifestation of the Honorable Barbers is noted by the committee. The Honorable De Lima.
Thank you, Madam Chair. This is actually supplementary or complementary to the manifestation made or the opinion made by the Honorable Representative Barbers. The ultimate general ground, betrayal of public trust. The specific allegation is alleged drug addiction of the president. And again, I would point out to certain sub-allegations and refute their insufficiency. Allegation number one, sub-allegation number one, there are serious accusations that PBBM is a drug addict. The offense alluded for this ground is drug addiction. Stating that there are accusations do not constitute factual allegations of the addiction. This ground presupposes that because PBBM is an addict or an alleged addict, he is unfit to be president.
However, unfitness per se is not a ground for impeachment. And even when considered as constituting basis for betrayal of public trust, the statements in this ground do not sufficiently establish allegations on how specific presidential acts were impaired by PBBM's addiction, assuming the addiction to be true. Second sub-allegation, Senator Amy, the sister, admitted or alleged or announced that PBBM is a drug addict. Again, this is not a factual allegation, but a conclusion that because Senator Amy admitted or announced that PBBM is an addict, then he must be an addict. The most that can be made out of this ground is that there was betrayal of the public trust because of PBBM's failure to disclose his addiction. However, the recital of allegations to this ground is still insufficient in terms of showing the nexus. Kasi yun po importante. The nexus between the facts raised or alleged and betrayal of public trust. Public accusations of PBBM's addiction, Senator Imy's claim of PBBM's addiction, PBBM's refusal to submit to a drug test, and his silence on accusations of being an addict still do not constitute the factual allegations necessary to satisfy the legal exercise in the formulation of causes of action that, assuming that they were all true, they establish betrayal of trust. Another sub-allegation is the PBBM is a drug addict because he refuses to submit to a drug test. Again, this is a conclusion and not a factual allegation. Nasabi ko na rin po, that kind of an allegation is still insufficient. The fact that he refuses to submit to a drug test. Another is by being silent. Sabi sa complaint. By being silent on his drug addiction, PBBM betrayed the public trust. For me, Madam Chair, this is a non sequitur conclusion and not a factual allegation. Because the ground must not only state a categorical allegation that PBBM is a drug addict and that this impairs the performance of his mandate, but must also include a recital of the alleged acts, events, and incidents that support the same. How do they say, or how do they know, or why do they claim that it impairs his judgment? So that's again my view. Again, this second ground is insufficient in substance. I so submit. Thank you, Madam Chair.
Manifestation is noted by the committee. The Honorable Santay.
Thank you, Madam Chair. On the second ground, alleged unfitness due to drug addiction, President Marcos is alleged to be a long-time user of illegal drugs. Drug use allegedly asserted is that drug addiction impaired. Medical evidence presented. No drug test. Medical evidence presented. No drug test results. So the allegations were merely limited. The evidence of drug use were merely limited to media reporting and political statements made by Senator Amy Marcos. In Philippine impeachment jurisprudence, it has never recognized personal health allegations without proof of impeachable offense, of the impeachable offense. And with regards to the second complaint, there were actually no general, there were actually no evidence, actual evidence presented to justify the allegations.
You're referring to the second offense.
Yes, with regards to the second offense.
Thank you.
Madam Chair.
Honorable Garbin first, then Honorable Po. Honorable Garbin, you are recognized.
Thank you, Madam Chair. On the alleged drug addiction and moral unfitness, the key factual allegations by the complainants were the President is accused of being a long-time user of illegal drugs, including cocaine, and central reliance is placed on public statements by Senator Amy Marcos, the President's sister, alleging or acknowledging his alleged decades-long struggle with illegal drug use. And the legal framing of the complainant is that not framed on any criminal accusation, and it is used to support the moral unfitness, the impaired judgment, and the betrayal of public trust. The allegation that the President is a drug addict is insufficient in substance. It is unsupported by competent evidence, such as medical findings, sworn admissions, or official investigation on record, and rests largely on hearsay and public speculation. Absent verified and authoritative proof showing impairment in office or misconduct indirectly related to the exercise of presidential functions, such allegation cannot establish impeachable offense and should not be given weight, Madam Chair. Thank you.
The manifestation is noted. We will be limiting the manifestations and comments with respect to the second offense to the two last members. These are Kong Po and Kong Lorden Suwan. We encourage the other members to participate in the discussion of the succeeding offenses.
Madam Chair, can you add me for the second charge? Very short
All right.
manifestation.
Now we recognize the Honorable Po.
I'll make mine as quick as possible so that we can accommodate Kong Rufus. So with regards to my manifestation, Madam Chair, what we've established through everyone who has manifested ahead of me is that there's no record of illegal drug abuse. That is clear. What we know for a fact and what is actually on record is that on November 2021, there was a negative drug test that was attested to at St. Luke's. And further, on May 2024, there was actually a Senate hearing in which one drug analyst, Jeresa Reyes, and laboratory head, Dr. Cecilia Lim, confirmed that the President tested negative specifically for cocaine. So while there is no existing record of any drug abuse, the President has on 2 occasions proven that he is not a drug user. I submit that to the record so that we can make a objective decision on the substance of the second ground.
The manifestation is noted. The Honorable Lorden Suwan.
Madam Chair, this is my manifestation. So there is an allegation in the complaint that there was an admission by Senator Amy Marcos that the President used drugs. However, this admission cannot be considered because of Rule 7, Section 17 of our own House rules regarding impeachment, which states that the rules of court apply suppletorily. We should consider Rule 130, Section 28 of the Rules of Court regarding the res inter alios acta rule, which merely states that an act of one cannot prejudice another, meaning that the so-called admission of Senator Amy cannot prejudice the President, which means that the so-called admission has become irrelevant and cannot be considered as one of the bases for sustaining sufficiency in substance.
Our last committee members to comment on this are the Honorable Rodriguez and then Honorable Vice Chair Dumogan. We encourage the rest of the members to participate in deliberating the succeeding other offenses. The Honorable Rodriguez.
Thank you, Madam Chair. This is a clear example of not a recital of facts, but a conclusion of fact not based on any evidence. There is no evidence that the President is using drugs. Only statements of some persons. And then, this particular allegation, being a mere conclusion, does not connect to any of the 6 grounds of impeachable offenses. And so therefore, clearly, this particular second act complained of has certainly it's not sufficient in substance. Thank you, Madam Chair.
Thank you. The manifestation is noted. Vice Chair Dumogan.
Thank you, Madam Chair. In addition to what already been said, which I fully agree, reliance on newspaper clippings is not sufficient. The Supreme Court in Estrada versus Desierto had noted that newspaper reports cannot prove the truth of their contents and generally considered as hearsay. So, looking at all the arguments, because as we said, there's no narration of facts, the arguments will not somewhat come out with a legal conclusion that the President violated a culpable violation of the Constitution, being a drug addict.
Thank you, Vice Chair Dumogan. The Honorable Padiernos will be the last speaker on the second offense.
Thank you, Madam Chair. I was already preparing for the next one, but
Would you like to
I
skip?
just wanted to join the Honorable Barbers in stating that the impeachment cannot proceed on rumor or hearsay. So that is very clear under the rules. And as mentioned by the Honorable Suwan, the res inter alios acta rule apply. So, and in addition, personal allegations unsupported by medical or judicial findings do not constitute the impeachable offense of betrayal of public trust. That's it, Madam Chair. Thank you.
That ends our discussion on the second offense. Now we are moving to the third offense. Please let the chair read. Respondent failed to veto unprogrammed appropriations and other unconstitutional provisions of the General Appropriations Bill for 2023, 24, 25, and 26. The same is anchored under either some or all of the following grounds: graft and corruption, culpable violation of the Constitution, and betrayal of public trust. At this juncture, we elicit the opinion, comment, reaction of the members to this allegation.
Madam Chair.
The Honorable Amben Amante.
Yes, about the unprogrammed funds. Actually, ma'am, since 1989, ay may mga unprogrammed funds na po. Even during the term of President Corazon Aquino. At ngayon, Madam Chair, kinikilala din ito ng ating gobyerno. Actually, yung unprogrammed funds ay nasa General Appropriation Act yan. At matatagpuan yan sa unprogrammed appropriation or sa under ng Special Purpose Fund. So, mahalaga din ito, Madam Chair, sa ating Pangulo, if just in case na magkaroon ng mga calamities or unforeseen expenditures. Halimbawa, may mga nasirang kalsada, nasirang tulay, diyan pwedeng kunin ng ating Pangulo yung pagpapagawa do sa mga naturang mga infrastructure project. Dahil baka mamaya, halimbawa, masira halimbawa ang South Luzon Expressway just because of the earthquake. Hindi naman pwedeng aantayin yung susunod na taon para maipagawa ito dahil maraming nakikinabang. So, ayun lamang po, Madam Chair, yung ating komento about the unprogrammed funds. At I don't think na kinakailangan ibito ito ng ating mahal na Pangulong Bongbong Marcos.
Thank you. The manifestation is noted. Any other comment?
Madam Chair.
The Honorable Eming Pascual.
Yes, Madam Chair, the inclusion of unprogrammed appropriations in the national budget has been practiced since 1989 up to the present. Since the administration of President Aquino up to the present administration of President Marcos, the inclusion of unprogrammed appropriations in the national budget has been accepted. It's been already become a matter of tradition and public policy to include unprogrammed appropriations in the national budget. Ang hindi pagbeto ng Pangulong Marcos sa kabuuang unprogrammed appropriations ay hindi paglabag sa anumang provision ng saligang batas. Hindi rin siya nagkasala sa taong bayan. Binigyan lang ng Pangulo ng pagpapahalaga yung nagdaang mga administrasyon. Imagine 7 administrations from Cory Aquino to former President Ramos, former President Estrada, former President GMA, Pinoy Aquino, and Duterte administration, itinuloy lang po ito ng Pangulo. And lastly, once the unprogrammed appropriations is included and approved in the national budget, President Marcos is not the one implementing it, but the agency concerned like the DPWH. Yun lang po. Thank you, Madam Chair.
Thank you, Honorable Pascual. Any other member who wish to comment on this?
Madam Chair.
The Honorable Erice, and then Honorable Acosta, and then Honorable De Lima, one after the other. And then Honorable Rodriguez. Honorable Erice, you are recognized.
Madam Chair, I think the issue of the 2023, 2024, and 2025 budget and the program appropriations and other items that are that has been questioned even by the investigation of the Blue Ribbon Committee is a very complicated matter. Sa tingin ko po ay walang personal na kaalaman yung complainant tungkol dito. Kaya po hindi po niya naipresenta ng maayos yung ang complaint na ito, at sa tingin ko po ay hindi niya maiugnay batayan lamang yung mga news articles. Kaya sa tingin ko po ay hindi sapat yung substance ng complaint na ito. Salamat po.
Thank you, Honorable Erice. Next is the Honorable Acosta.
Thank you, Madam Chair. Just 2 points. First is on the veto power of the President, Madam Chair, that the power of the President to veto bill or specific items in an appropriations bill under Article 6, Section 27 is a discretionary power, not a mandatory duty. Jurisprudence dictates in that landmark case of Bengzon versus Drilon establishes that the President cannot be compelled to exercise a veto. Therefore, Madam Chair, a failure to veto cannot be a definition or a culpable violation of the Constitution. Second is on the attachment on paragraph 25, on that case of Pimentel et al. Versus House of Representatives, Colmenares versus Executive Secretary, GR numbers 274778, where the Supreme Court declared part of the law unconstitutional, does not automatically mean that the President is culpably violated the Constitution by signing it. If it were the case, Madam Chair, that every President who signed law was later voided would be impeached. There must be proven bad faith, which the complainant fails to allege in this instant, Madam Chair. Thank you po.
The manifestation of the Honorable Acosta is noted by the committee. Next is the Honorable De Lima.
Thank you, Madam Chair. As to this third ground, the specific ground of failure to veto unprogrammed appropriations and other provisions of the 2023, 2024, and 2026 GAA, as allegedly constituting betrayal of public trust. My view, again, is that these are insufficient, or this ground is insufficient in substance. Again, there are three, I point to...
Honorable De Lima, because we do not want to miss your valuable opinion on this, kindly speak closer to the microphone.
Thank you, Madam Chair. So this specific ground has, again, three sub-allegations that I see from the face of the complaint. Number one, PBBM did not veto unprogrammed appropriations. There is lack here of specification of how the alleged omission was committed other than a general averment, and the provision of law or constitution violated in the omission. Number two sub-allegation, PBBM wanted to preserve discretionary control over public funds. It lacks specification of the acts committed and the provision of law or constitution violated. The third sub-allegation, PBBM subverted the power of the purse and violated the Constitution when he did not vote. This is a conclusion of law and not a factual allegation. So all of these allegations under this third ground fail to establish the nexus between the alleged failure to veto on program appropriations and betrayal of public trust. This ground does not go further than argue that because PBBM did not veto on program appropriations, therefore he betrayed the public trust. Well, we know that with respect to the general ground of betrayal of public trust, there is much leeway because this is supposed to be a catch-all provision, like a culpable violation of the Constitution, unlike the others like treason, graft and corruption, and bribery. But it cannot possibly conceive or cover all imaginable or all conceivable acts of wrongdoing or failure of judgment. Now, this conclusion must be preceded by a recital of factual allegations establishing why exactly PBBM's refusal to exercise his veto power on unprogrammed appropriations amounts to a violation of the law and the Constitution. Personally, Madam Chair, along with the Honorable Chair Egay Erice, I always held the view that unprogrammed appropriations in the budget are of questionable constitutionality. That's why we filed a petition before the Supreme Court. But the issue here is not the constitutionality of the unprogrammed appropriations, but whether the facts as alleged on the face of the complaint has a connection or can satisfactorily establish betrayal of public trust. As I said, again, these are mere conclusions and therefore insufficient. Thank you, Madam Chair.
Thank you, Honorable De Lima. Now we
Madam Chair.
recognize the Honorable Rodriguez. Honorable Rodriguez, then Honorable Chua, then Honorable SDML Defensor.
Thank you, Madam Chair. Manifestation very short. Again, this particular third act does not constitute, it does not have comply with the requirement of sufficiency in substance because the President has that discretion to veto or not. If it's veto, that's the end. You try to have it again, probably convince the President the next time to veto. If it's veto, the only solution is not even the committee. It goes back to Congress to override it. And the problem here really is this Article 210 of the revised penal code, committed only in times of war. Third is a case of bribery. That's 114 of the revised penal code, direct bribery, knowingly receiving. And then the fifth is other high crimes. American, we have no decision on this, but American laws, it is such gravity that it involves already its effect on the nation by these officials. But betrayal of public trust is a matter of public policy to be done by Congress. We will be the one to decide what is betrayal of public trust. And to me, there is a failure of the narration of facts to say that the failure to veto of unprogrammed appropriations will be a betrayal of public trust. That's so far from this title of this act to the constitutional requirement that there should be betrayal of public trust. So therefore, that is my manifestation. Again, no substance in this case. Thank you.
Thank you, Honorable Rodriguez. Now we recognize the Honorable Joel Chua.
Thank you, Madam Chair. Madam Chair, the third issue relies solely on the failure of the President to veto the unprogrammed appropriation. So yung pag-veto lamang po ang kino-question niya po dito. But we know for the fact that the veto power is the exclusive prerogative and power of the President. Not even the President, not only the President, but all local government executive. Maski po sa mayor, governor, they all have this veto power, and that is exclusive. Hindi po ito mandatory on them, pwede po nilang i-veto kung ano pong item sa budget. So that is their prerogative. Kaya hindi rin po nakastate dito sa fact na to kung bakit ito kung ano pong crime ang na-violate ng presidente sa kanyang failure sa pagdito ng nasabing unprogram appropriation. That's why, Madam President, Madam Presiding Officer, the third issue, the third ground, I believe, does not or is not sufficient in substance.
Thank you, Honorable Chua. Next is the Honorable SDML Lawrence Defensor.
Thank you, Madam Chair. To veto or not to veto is a political question, which was clearly stated by the Supreme Court in the case of Tañada versus Cuenco, that political questions are those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or those which full discretionary power has been delegated to the executive or the legislative department. The exercise or the non-exercise of that power by the President when it comes to the national budget is a non-impeachable offense. So therefore, let's move on to the next offense, Madam Chairman.
Madam Chair.
Thank you. Now let us recognize the Honorable Suntay.
Thank you very much, Madam Chair. On the third ground, on the failure of the President to exercise his veto power, the legal theory asserted is that his failure to veto unconstitutional provisions is tantamount to betrayal of public trust. The evidence cited were Supreme Court rulings voiding certain budget provisions, DBM documents, and news reports. However, as we all know, the presidential veto power is discretionary to the one wielding it. It is his prerogative to use it or not to use it. If he chooses not to use it, it is not an unimpeachable offense because it is discretionary upon the person holding it. It is also not the constitutional. It is also not a constitutional duty to veto every unconstitutional provision because we have to first determine which provisions of the budget of the GAA is unconstitutional, and at that time, there was no determination that the provision was unconstitutional. So, thirdly, we cannot impute culpability on his failure of not using it because it requires proof that there was bad faith and corrupt intent. That's why the President did not use his veto prerogative. So, Madam Chair, that is my position on the third allegation.
Thank you, Honorable Suntay. The Honorable Tino.
Thank you, Madam Chair. Madam Chair, I agree with some of the positions expressed here that in this case of the third act, under discussion, what is in question is the exclusive discretion of the President to veto, the veto power of the President. And the allegation here is that that veto power was abused. Okay, now abuse may be done through a positive act or also through inaction when discretion is required. So, in the case here, one allegation is that the President failed to veto unconstitutional provisions. Now, it may be the case that there are certain provisions in the budget that are blatantly unconstitutional or illegal, in which case the President precisely has been given the veto power in order to address that. And if you read the presidential veto messages, veto of certain specific provisions are often justified by the President explaining that this particular special provision approved by Congress will be in conflict with existing laws. Therefore, it is vetoed. No? So therefore, tama lang po, pwede pong maging ground for impeachment yung hindi pag-veto. Lalo pa kung talagang lantad na illegal ang provision na yon, no? For example, unprogrammed appropriations may be sourced from PhilHealth funds. Okay? That is blatantly unconstitutional because there is a sin tax law. Okay. However, what I do notice in the complaint is that there was an allegation that the President failed to veto unconstitutional provisions in multiple national budgets. However, the complaint does not specify which particular provisions are unconstitutional and required veto. So there is merely a general allegation. So the recital of facts appears to be lacking, Madam Chair.
Thank you. For the last speakers on the third offense, we will be calling the Honorable Po and then the Honorable Vice Chair Dumogan. Honorable Po.
Madam Chair, thank you for recognizing me. In this instance, we have to take into consideration the implications of finding substance in this ground. Because if we are to say that this has substance, then we are admitting or we are taking away from the willful action that must be provided if we're to see grounds for impeachment. What's important to note here is that if we say that the President was lacking in his duty because he did not exercise his veto power, then we are putting a premium on the veto power, saying that the veto power is actually the job of the President and not an exceptional function of his office, in which the President is no longer in charge of execution. Now the President will be in charge of the judicial function of deciding whether or not every provision of the GAA is constitutional. So is the President the head of the judiciary, or is he in charge of executing? Now, there are, as Representative Tino stated earlier, certain areas in which the President can exercise his veto right, but I maintain, and I think that my fellow colleagues here should consider, that this is always the exception in the role of the President, and that the veto power is not the primary function of his office.
That's the meaning of prerogative, to veto or not to veto. Now we proceed to the Honorable Vice Chair Dumogan.
Thank you.
Our last speaker on third offense.
Thank you, Madam Chair. In addition to what had already been said, which I fully agree, let me point out that the budget which the President failed to veto was passed by both houses of Congress. Why should we fault the President if he did not exercise his discretionary power to veto what had been passed by both houses of Congress? On that score alone, I do not think that it can be considered as illegal violation, which is tantamount to culpable or willful violation of the Constitution on the ground of betrayal of public trust or corruption.
That ends our discussion on the third offense. The committee acknowledges all the significant comments and opinions on whether or not there is a recital of facts that constitute an offense determinative of the jurisdiction of the Justice Committee. Let us all be reminded by our parameter that we need to establish the offense to the ground of impeachment under which the same is anchored. Now we are moving to our fourth offense. Please allow the chair to read. Respondent benefited from kickbacks arising from budget insertions and ghost flood control projects. At this juncture, the chair elicits the comment, opinion, and reaction of the committee members.
Madam Chair.
Mag-walk out ka uli.
Hindi na.
The Honorable Abante is recognized.
Pag-uusapan ngayon eh. Oo, kaya kasama na rin ako dito. But anyway, ito pong fourth allegation. Isa lang ang sabihin ko dito. Nakalagay po sa ating rules, if it finds that sufficient grounds for impeachment do not exist, the committee shall dismiss the complaint and submit the report required hereunder. Ito po, it does not actually exist because everything that is said here is hearsay. Yun lang po.
Thank you. The Honorable Rodriguez.
Madam Chair, in this fourth act, which is alleged, it is clearly based on the fourth ground of impeachment, which is graft and corruption. The Supreme Court, in the case of Francisco versus House of Representatives, clearly already said that this is defined under the Republic Act 3019, which is the anti-graft code, the anti-graft law, which provides Section 3B and C. These are the main, if this is an allegation of a public official who receives kickbacks and from ghost projects and so forth, it should be under this. And it is clear, Madam Chair. We have to therefore go whether there's a recital of facts in relation to, Madam Chair, Section 3B and C. And here we go. This is now what it says, Madam Chair. It says, Section 3A, knowingly, deliberately, requesting and receiving money because of an important project or permit to be issued by the person. There is no allegation here, Madam Chair, that the President requested, that the President received money because he has a permit or contract to give. That is precisely what is stated here under Section 3A. Directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself or for any other person in connection with any transaction or contract between the government and that party. The second one, 3C, also is directly or indirectly requesting or receiving any gift and so forth for himself and another in a manner or capacity that has secured or obtained this particular permit. So there are only two. There are only two provisions under Republic Act 3019, wherein, according to the Supreme Court, the fourth ground could be ang President. And then attached copies of the video expose. To question always, this is the cross-examination. This is the time to question always. This is the cross-examination. This is the time to also provide the respondent the time to question, cross-examine the person who said that the money was given. And he is not in this country. He's either in Portugal or Sweden. This country is either in Portugal or Sweden. And so therefore, Madam Chair, once again, the fourth ground, Chair, once again, the fourth ground, which is respondent engaged in graft and corruption through kickbacks and ghost projects. Respondent engaged in graft and corruption through kickbacks and ghost projects. There is no recital of facts that will constitute.
Thank you, Madam Chair. Yes, thank you, Madam Chair. Yes, on allegation number 4, respondent engaged in graft in corruption through kickbacks and ghost projects. The allegations which seem to justify the said charge are contained in paragraphs 27 up to 32. Reading all these paragraphs, they do not contain the narration of facts that will pinpoint to the President, that will somewhat allude an illegal violation which is tantamount to graft in corruption. What had been stated here are allegedly given to certain allies. It's too vague and too wide to consider. So, looking at all of these allegations, clearly it does not justify the ground, again, to impeach the president on graft in corruption under the provision of Article 10, Section 11 of the Constitution.
Thank you, Vice Chair Dumogan. Our last speakers for the fourth offense are the Honorable Acosta, the Honorable De Lima, and the Honorable Colliantes, one after the other. The Honorable Acosta is recognized.
Thank you, Madam Chair. This is just a reiteration of my two senior compañeros. Is the lack of the ultimate facts required for a charge of graft and corruption based on the 6 paragraphs of the number 4 allegation, Madam Chair. It mentions suitcases of cash and ghost flood control projects. But Madam Chair fails to provide 1, specific dates, 2, specific persons involved, 3, specific project names, and lastly is the direct links to the President's personal involvement in this case. Madam Chair, it is my humble opinion that these are generalities and broad generalizations, which according to the Supreme Court, in that case of Gutierrez versus House of Representatives, GR number 193459, are insufficient for impeachment, Madam Chair. Thank you.
Thank you, Honorable Acosta. Next is the Honorable De Lima.
Thank you, Madam Chair. As to this fourth ground, general ground, graft and corruption, and the main specific allegation that allegedly the President benefited from kickbacks arising from budget insertions and ghost flood control projects, with 4 sub-allegations. 1, PBBM orchestrated insertion in GAA for kickbacks. I agree with the Honorable Acosta that it lacks specificity as to what, how, and when, making this a conclusion rather than a factual allegation. The nexus, again, between the factual allegations and the ground of graft and corruption was not established due to the lack of specificity of the allegations in how PBBM orchestrated the flood control scam for kickbacks, other than by sweeping statements that are more of conclusions than allegations of specific acts. Sub-allegation number 2, suitcases of cash were delivered to PBBM's political allies. Again, lacks specificity as to who, what, how, and when. Sub-allegation number 3, the ghost flood control projects confirm plunder of public funds that is not possible without PBBM's approval. This is a conclusion rather than a factual allegation. The fourth and the last sub-allegation for this ground is PBBM is allegedly the central figure in corruption schemes. This is again a conclusion rather than a factual allegation. In all of this, in light of the evidence uncovered, I just wonder, in light of the evidence uncovered in the multiple fora investigations conducted on the flood control scam, medyo kapos talaga sa allegation yung complaint. It seems overly complacent for the complainant to be sparing in his factual allegations as to establish the ground for impeachment. For me, Madam Chair, there is simply paucity of factual allegations. Again, this is insufficient.
Thank you, Honorable De Lima. Our last speaker on the fourth offense is the Honorable King Colliantes.
Madam Chair, I'd just like to manifest my support for all of the comments said by our dear colleagues. But really, the question right now here is, are these just conclusions made by the complainant, or are these really based on fact? Remember, we have to go back to the verification, which says that all of his allegations must be based on personal knowledge. Does the complainant have personal knowledge? Was he there when these alleged transactions happened? Does he have any basis based on authentic records to say that money was transferred, money was provided to the President? I doubt it. So I think based on what is written on the complaint, it is insufficient as a ground for impeachment. Thank you, Madam Speaker.
Thank you, Honorable Colliantes. That concludes our discussion on the fourth offense. Now we are moving to the fifth offense. Please allow the chair to read. Respondent created the ICI to shield corrupt allies. So this is the offense, and the same is anchored under any, some, or all of the following: graft and corruption, culpable violation of the Constitution, and betrayal of public trust. At this juncture, we elicit the comments and opinions of the committee members. First, we recognize the Honorable SDML Lawrence Defensor.
Thank you, Madam Chair. I would have to speak. I'm compelled to speak for the membership of the ICI regarding this allegation that it was created to shield corrupt allies. Madam Chairman, the appointment and participation of the members of the ICI, particularly Secretary Rogelio Singson, whose integrity and reputation speaks of good governance, contravenes the allegations by this impeachment complaint head-on. Hindi ka maglalagay ng mga taong naging ehemplo ng mabuting patakaran at pamahalaan kung ang balak ay pagtakpan ang korupsyon. So the membership itself of ICI, a presiding justice of the Court of Appeals, an SGV partner who is a partner on audit, and someone like Rogelio Singson, who is a model for good governance, clearly runs contravene against this allegation in the creation of the ICI. Thank you, Madam Chair.
Thank you, Honorable SDML Lawrence Defensor. The Honorable Franz Legaspi is recognized.
Thank you, Madam Chair. I'd just like to give a very short manifestation to take note of the evidence or the annexes presented, the evidence in the annexes presented. For me, and this is a general observation as well with the earlier topics, but in particular for this ground, there are a lot of evidences the sources are only media outlets, news sources, and I think this was generally already noted by our members of this committee. But in this particular ground, these articles are, I think, 4 opinion columns, mostly predicated on the opinions of certain personalities, certain characters. And I think in relation to the particular ground that the complaint wishes to state, I believe I think it's clear the betrayal of public trust with regard to the creation, or rather the ICI's creation, somehow affecting or resulting in a loss of public trust, which would, in this case, be a ground to impeach the President. I think it's very clear on that part that the evidence presented is not directly related to that particular ground. And also, it's also vague with regard to the metrics or how it could match or say that there was a betrayal of public trust or that the trust ratings are affected by the creation of the ICI. So that's my humble submission, Madam Chair. For me, I think this is, just based on this ground is already insufficient in substance as well. So thank you, Madam Chair.
Thank you, Honorable Legaspi. We are on the last offense. This is the allegation that the creation of the ICI is used to shield the allies of the impeachable official. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. Again, it appears that this is one of an allegation that is not at all supported by narration of facts. In fact, as we all know, aside from what had already been stated, the integrity and competence of the members of the ICI appointed can disprove this fact. Second, they have investigated all those that had come to their attention related to corrupt implementation of projects, which clearly disprove the allegation that it has been created to shield certain allies in government. So it's far, far away from establishing a legal violation which is considered as willful violation of the Constitution as an impeachable offense. Your Honor, thank you, Madam Chair.
Thank you, Vice Chair Dumogan. Any other comment or manifestation from the members? The Honorable Po.
Madam Chair, the creation of an anti-corruption body in and of itself is not an impeachable offense. Now, there's an assumption in this grounds that it was used for shielding. However, what we actually have evidence of in terms of the ICI's actions is that its investigation included both allies and non-allies alike. Its recommendations also had both allies and non-allies alike. And if we're going to discuss further, I would caution our colleagues on finding substance in this, because we do not want to discourage future anti-corruption efforts. We don't want to discourage future transparency efforts. What we're discussing is the willful violation of the Constitution. But what we have here on record is the willful act of the President for transparency and accountability. That's what we have objective fact on. So I just want to make sure that we are not dissuading efforts for transparency and accountability within our government by finding substance in this.
Madam Chair.
Thank you. The Honorable Rodriguez.
Madam Chair, I take exception to this particular ground for impeachment. I personally know a former Secretary of Public Works and Highways, Rogelio Babe Singson. I was already Congressman of the 2nd District of Cagayan de Oro. And he often comes to Cagayan de Oro to be able to look at projects. And during his time, and even up to now, there are no ghost projects in Cagayan de Oro 2nd District, nor any substandard project. Now, he would not accepted if this is a shield. And he would not have continued until he, because of health reasons, has to therefore resign. But during the term that he was there, together with the SGV representative and former Presiding Justice Reyes, it was clear that they were able to invite and get documents. And some have already been recommended for filing. If this were a shield, then there would have been no action of the ICI. But there were many already given to the Ombudsman for investigation and preliminary investigation. So therefore, this is something that it does not give justice to those who have already been appointed and had worked on this particular ICI. And so therefore, I personally know the former secretary, and I was very happy that despite the fact that, he has been retired, he's retired, he took the job because he believed that the ICI can make a difference in stopping all of this flood control mess, and then be able to send the proper cases and documents to the Ombudsman, which is the jurisdiction over cases of graft and corruption and plunder. Thank you very much, Madam Chair.
Thank you. Next is the Honorable Lord Ansuan.
Madam Chair, the body of the complaint does not contain any express provision in the ICI's charter that limits investigations only to political opponents, nor does it contain any instances of limiting of any instances or policy or rule exempting allies. In fact, I remember that even the President's son was summoned to the ICI. Nor does the complaint state any rule by the ICI which bars or obstructs any investigation against allies. And I have seen several instances in which supposed allies of the President were summoned to the ICI. To emphasize, the President has the authority to create ad hoc investigative bodies to ensure faithful execution of our laws. And saying so, the ICI is only a recommendatory and fact-finding body. Furthermore, allegations of political targeting are only speculative. and bad faith cannot be presumed. They must be proven with particularity.
The Honorable Garbin.
Thank you, Madam Chair. The establishment of such body like the ICI falls within the President's executive and administrative discretion, which we have constantly regarded as political question and which is outside the ambit of this honorable body. Be that as it may, the complaint likewise does not allege ultimate facts showing abuse, unlawful purpose, or concrete acts of favoritism directly attributable to the President. Absent specific evidence demonstrating selective enforcement or deliberate shielding of particular individuals through identifiable presidential acts, the allegations, Madam Chair, remains conclusory and cannot sustain a finding of an impeachable offense.
Thank you. Any other member?
Madam Chair,
The Honorable Abante.
if I would like to give my own manifestation on this.
Is this on the fifth
Hindi-
offense?
Ano po yun?
Is that on the fifth offense?
Yes, yes.
You may proceed, Honorable Abante.
Although the ICI should have been given more powers to investigate and to subpoena, na hindi po nangyari. Ito pong si Attorney Andre De Jesus. Hindi ko alam kung anong klaseng abogado ito. Pero nakakahiya naman doon sa members ng ICI na magaling mag-imbestiga at para bang sila din po ay nagkasala din at nagkamali rin sa taong bayan. I just would like to say na walang kwenta po itong sinasabing itong tinatawag natin na respondent created the ICI to shield corrupt allies. Siguro po, kung siya ang presidente, gagawin niya yun. But the thing is this, no, ha? Palagay ko talagang wala na pong sufficient grounds itong impeachment na ito. Dapat talaga ibasura na ho natin ito sa lalong madaling panahon. Maraming salamat po, Madam Chair.
Madam Chair. Madam Chair.
Honorable Abante, let us be cordial to our complainants.
Madam Chair.
Nonetheless, we recognize the Honorable Erice.
Madam Chair, nakakaasar na rin po kasi.
All your manifestations are noted.
Madam Chair, I would say that the ICI is a complete failure. As evidenced by the resignations of the two members of the ICI. Pero hindi po nakakahulugan ito na ang Pangulo ay ginawa ito para pagtakpan yung kanyang mga allies. Ito po ay isang speculation at isang conclusion rather than a fact. So, Madam Chair, I don't think that this is a sufficient basis to impeach a president. Thank you.
Thank you, Honorable Orice. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I think we had lengthily discussed the 5 grounds of the De Jesus
Correct.
impeachment complaint. And if we are ready, let us now vote on the
You would
sufficiency.
like to vote already?
Yes. Unless
We
will have
acknowledge
it
the
tomorrow.
contribution of all the members
Okay.
for having this exhaustive and lengthy discussion on whether or not the recital of facts actually constitute an offense determinative of the jurisdiction of the Justice Committee, no? We've heard significant discussions on the needed ultimate facts, that there must be specific details for us to be able to substantiate the offense which constitute the ground for impeachment. We've heard also discussion about the need for authenticity of not only the records but even the video. We've heard also about the need for personal knowledge with respect to the allegations of the facts in the impeachment complaint, as well as the nexus which was repeatedly mentioned by the Honorable De Lima. It's not enough that the impeachable offense is, or the impeachable official is guilty of an offense. That offense must constitute a ground for impeachment, no? I hope that all our significant discussions will be used by the honorable members of the committee when we vote on whether or not the impeachment complaint of De Jesus is sufficient in substance. In that regard, I wish to share to the committee that the chair is in receipt of request to do the voting on the sufficiency in substance of De Jesus' complaint on our succeeding meeting, that is tomorrow. The reason is to give time to the members of the committee to ponder, decipher, evaluate all the comments and opinions we've heard today. So, if all the members are amenable to that, contrary to what we did yesterday, we concluded our deliberation already about the sufficiency in substance of De Jesus' complaint, but we will be voting on this tomorrow afternoon after we are done with our deliberation on the sufficiency of substance of the Massa et al. Complaint. We wish to seek also the understanding of the endorsers and even the complainants in Massa et al. Complaint. Medyo naging exhaustive po ang ating discussion, and we want to give time to the members of the committee to recharge, to have a fresh mind when they listen to the manifestation of position of the endorsers of the Massa et al. Complaint. So, on that point, if the endorsers and the complainants as well as the members are all amenable, we will be listening to the manifestation of position on sufficiency and substance of Massa et al. Complaint tomorrow, that is Wednesday, and we will be voting on the sufficiency in substance of both the De Jesus complaint and the Massa et al. Complaint tomorrow as well. Do all the members agree to that? If so, if there are no other matters you would like to discuss in today's hearing, then the chair is suspending our today's hearing until tomorrow, February 4, 2026, 10 o'clock in the morning. The members present today are considered informed in today's hearing. Our hearing is suspended.